Any time. This hearing is entitled Ensuring Effectiveness, Fairness, and Transparency in Securities Law Enforcement. I now recognize myself for 2 minutes to give an opening statement. Today's hearing on ensuring effectiveness, fairness, and transparency in securities law enforcement will focus on the Securities and Exchange Commission's approach to enforcing federal securities law and whether its activities and initiatives are complementary to all three prongs of its statutory mission: to protect investors, to maintain fair, orderly, and efficient markets, and to facilitate capital formation. According to the Division of Enforcement's annual report issued in November of 2017 in fiscal year 17, the SEC brought 754 enforcement actions and obtained almost $3.7 billion in disgorgement and civil penalties resulting from those actions. Additionally, $1.07 billion was returned to harmed investors. Enforcement activities are an integral part of any regulatory agency, but especially for the SEC. Hardworking families in West Michigan and across the nation rely on capital markets to save for everything from college to retirement. We must work to ensure the United States continues to maintain the most efficient capital markets so that Mr. and Mrs. 401k have the opportunity to safely invest in a better future and receive the greatest return on their investment. This hearing will further discuss areas of the law that will benefit from greater clarity to ensure that the SEC investigations have an appropriate scope and minimize instances of the practice known as regulation by enforcement. Additionally, the hearing will examine the role of administrative proceedings in the enforcement of federal securities laws, including whether Congress should advance legislation like H.R. 2128, the Due Process Restoration Act of 2017. We will also explore whether Congress should clarify the SEC's authority to seek disgorgement, including what is the appropriate statute of limitations for disgorgement sought by the SEC. Lastly, we'll examine whether the lack of clarity between federal and various state standards for securities fraud, as well as other potential violations, is chilling participation in our capital markets. The United States capital markets are the gold standard. We can all acknowledge that our markets are widely recognized for being the deepest, most liquid, and the most competitive markets in the world, and Congress must identify any inconsistencies or disparities between state and federal laws and take appropriate action to ensure greater consistency and predictability in the application of these rules and regulations. I look forward to hearing from our witnesses today, and the chair now recognizes the ranking member of the subcommittee, the gentlelady from New York, Ms. Maloney, for 5 minutes for an opening statement.
Thank you, and I thank you for holding this important hearing, and I thank all of our panelists for being here. Proper enforcement of all the securities laws help maintain investor confidence in our markets. Investors need to know that their rights will be protected and that bad actors who try to take advantage of them will be punished. It's for this reason that I'd like to focus on one of the bills that we're discussing in this hearing today, H.R. 5037, the Securities Fraud Act of 2018. This bill is deeply, deeply troubling to me. The bill will and would completely preempt all state civil securities fraud laws and would actually preempt most and likely all state criminal security fraud laws, too. I have very serious problems with both the premise of this bill and the drafting of the bill, which has managed to make a bad idea even worse. First, the premise of the bill is fundamentally flawed. Companies don't need relief from state securities fraud laws. They need to stop committing securities fraud. The idea that securities fraud should be illegal and that states should be able to police securities fraud within their own borders should be uncontroversial. I believe that fraud is fraud and that states should be free to regulate any form of securities fraud that they see fit. Second, the way the bill is drafted, it actually preempts all state criminal securities laws, in addition to civil securities fraud laws. The bill's findings section says that states should retain the authority over criminal securities fraud, but then the bill proceeds to strip states of their authority over all criminal securities fraud cases. The reason is simple. The bill says that no state, and I quote, shall regulate securities fraud with respect to an issuer, end quote. This preempts both civil and criminal security fraud laws. The bill then later states that states can bring criminal securities fraud cases, but only, and I quote, consistent with this section, end quote. But that section of the bill has already stated that no state law can regulate any securities fraud, even criminal securities fraud. So it's literally impossible for any criminal securities fraud case to be consistent with that section, which means that all criminal securities fraud laws at the state level would be preempted under this bill. But I'm particularly opposed to this bill because in New York State, we have a powerful securities fraud law called the Martin Act, which has a broader definition of fraud than other states, and therefore serves as an effective deterrent for misconduct in the securities market. The Martin Act has been very successful, and I will strongly oppose any attempts to weaken this important law. For example, I have a letter here from the New York Attorney General's office which opposes H.R. 5037, and they highlight several cases that they brought under the Mann Act that they would no longer be able to bring under this bill. For example, just last year, they brought a case under the Martin Act against a small-time investment advisor in Queens who had defrauded about 58 investors out of $11 million. These are the kinds of cases that only the state securities regulators, like the New York Attorney General's office, can bring because the SEC simply doesn't have the resources to pursue every small-time fraud like this. And unfortunately, under H.R. 5037 seems to be aimed directly at the Martin Act, and by preempting these state laws, the bill would allow small-time fraud to run rampant. Before I close, I want to submit for the record letters of opposition to H.R. 5037 from the North American Securities Administration Association, the New York Attorney General, the Massachusetts Secretary of the Commonwealth, the New Jersey Attorney General, and the Council of Institutional Investors.
So moved without objection.
Thank you, and I look forward to this hearing from our witnesses, and especially from Mr. Borg, who is one of the state security regulators whose authority would be weakened under this bill. Thank you, Mr. Chairman, and I yield back. Thank you.
Gentlelady yields back, and while I have a moment, I had neglected to do one small point of business, and I just ask unanimous consent for any member to participate in today's hearing, although not a member necessarily of this subcommittee. As long as that member is a member of the full committee, we welcome that participation today. With that, I want to get rid of the hum that I'm hearing up here with this microphone. Sorry about that. But with that, the gentleman, the vice chairman from Illinois, Mr. Holtgren, is recognized for 2 minutes for an opening statement.
Thanks, Chairman Huizinga, for holding this hearing. Thank you all to our witnesses for being here. I think we can all agree that our securities laws are critical to providing structure and certainty to both issuers and investors participating in our capital markets. In turn, this certainty drives the capital formation and investor returns that are foundations to our American economy. It's important that Congress regularly review how the securities laws are being enforced and identify opportunities for our regulators to be more effective. Today's hearing is especially helpful in light of the testimony we heard in this subcommittee from the SEC's Division of Enforcement last month. In their testimony, the co-directors of enforcement underscored a number of things that I hope our witnesses can provide some more insight into today. Specifically, I believe that enforcement of our securities laws should prioritize protecting the least sophisticated investors. In other words, those that are most susceptible to fraud. Similarly, I agree that the basis for enforcement of our securities laws should not be the broken windows approach that has been used by the Commission in the past. I'm concerned that this could cause the SEC to overlook more significant investor protection issues that require more long-term resources to investigate. Finally, the recent Kokesh decision has ignited an important debate about the statute of limitations for disgorgement by the Commission. Last April, now SEC Commissioner Hester Pierce testified in our hearing on the Financial Choice Act about the importance of making reforms to the Commission's approach to enforcement, such as increased transparency, expanding opportunities for parties to present their positions in person, and allowing parties to opt out of administrative proceedings and into district court. I hope these are ideas that our committee can further develop and advance. I look forward to our witness testimony today and look forward to hearing the recommendations for improving the enforcement of our securities laws. With that, I yield back.
Gentleman yields back, and with that, the chair recognizes the gentleman from New Jersey, Mr. MacArthur for 1 minute for an opening statement.
Well, thank you, Mr. Chairman. I think we all know we have a problem in our public markets. The year I graduated from college, in 1982, there were about 5,800 public companies. It's about the same number we have today, except that our economy has more than doubled during that period. There's a lot of reasons why companies aren't going public, but the one I hear most often, the one I've experienced in my own life, is that business people are scared to death of overzealous attorney generals that criminalize mistakes and make it difficult for businesses to go forward. It hurts Main Street investors. It hurts employees who want to invest in their companies. And I think there's a simple remedy. The Securities Fraud Act that we'll discuss in part today retains in states policing power over criminal fraud, but it moves civil fraud to a single definition that requires intent, and it allows companies to repair to the federal courts rather than being twisted in the wind in multiple states with different definitions. And I look forward to discussing that in more detail. I yield back.
Gentleman's time has expired. Today we welcome the testimony of Mr. Bradley Bondi, who is a partner at Cahill, Gordon, and Reindel, LLP. We also welcome Mr. Joseph Borg, who is the Director of Alabama Securities Commission. He is here on behalf of NASA. This is the good NASA, the Financial Services NASA, North American Securities Administrators Association. And then we also welcome Mr. Thomas Quadman, who's the Vice President for the Center for Capital Markets Competitiveness from the U.S. Chamber of Commerce, and Professor Andrew Vollmer, who is the Professor of Law and Director of the John W. Glenn Jr. Law and Business Program at the University of Virginia School of Law. So each of you will be recognized for 5 minutes to give an oral presentation of your testimony, and without objection, each of your written statements will be made part of the record as well. So with that, Mr. Bondi, you are recognized for 5 minutes.
Good afternoon, Chairman Huizinga, Ranking Member Maloney, and distinguished members. My name is Brad Bondi, and I'm honored to appear before you today.
If you don't mind just pointing that microphone a little bit towards you. There we go. Thank you.
I am a practicing attorney and partner with the law firm Cahill, Gordon, and Reindel, where I lead the firm's securities enforcement and regulatory practices. Much of my law practice is devoted to representing public companies and financial institutions in securities enforcement cases before the SEC. I previously served in senior positions in the government, including as counsel to SEC Commissioner Paul Atkins and then SEC Commissioner Troy Paredes. Although I'm affiliated with a number of organizations, my views today are my own and do not necessarily represent those of my law firm or my clients. The SEC is an agency that I greatly admire and respect. In my years of serving at the Commission and in private practice, I've worked with many talented, dedicated, hardworking professionals at the SEC. And my observation is that the SEC as a whole overwhelmingly has sought to abide by its mandate, and for the most part has been successful in doing so. Nevertheless, there are some areas where the SEC can improve. One area where I believe the SEC has strayed from its mission is in its approach to financial penalties of public companies and disgorgement. A penalty against a company is directly borne by its shareholders. In other words, investors for whom it is the SEC's mission to protect. Previously, the Commission had a penalty statement that spelled out the circumstances in which it would seek a penalty against shareholders. But in 2013, several commissioners disavowed it. The amount of a monetary penalty is unpredictable because the SEC has not articulated criteria and metrics for calculating how much it will penalize a company, and also its approach to the remedy of disgorgement. This unpredictability negatively impacts companies. For example, the inability to predict the size of a potential penalty hinders the markets for mergers and acquisitions because potential bidders cannot accurately forecast regulatory exposure. I commend SEC Chairman Clayton and the current Commission for taking what appears to be a more measured and thoughtful approach to assessing monetary penalties, and I encourage the Commission to release a renewed penalty statement explaining the circumstances in which the SEC will seek a shareholder penalty and articulating the standards for disgorgement. I understand that in the wake of the Supreme Court's decision in Kotesh, there's been discussion about extending the statute of limitations for disgorgement and financial penalties. Although I believe it is critical for the SEC to pursue those who commit fraud, I am concerned about the cost of extending the applicable statute of limitations may greatly outweigh the benefits. 5 years is the longest period of limitations and repose found in any federal securities laws. Extending the statute of limitations beyond that would create uncertainty for the investing public because of the possibility the SEC may prosecute stale claims. It also could open up the door for inefficiencies in the way the SEC investigates if more time is allotted to bring those actions. In my 2 decades of experience as a defense lawyer, an SEC investigation into potential securities law violations by a public company, even an investigation that ultimately does not find any violations of law, can take several years, distract management, and cost the company tens of millions of dollars. The cost of that investigation is directly borne by the shareholders of the company. Of particular concern are SEC enforcement investigations that begin after a news story about a high-profile company, prompting the enforcement staff to pursue one theory of liability, but then morph into an open-ended investigation that wanders into other areas of a company in search of a potential violation. SEC investigations can impede entrepreneurship and innovation. I understand the current leadership at the SEC is cognizant of these concerns and has been working to address them. Policies and procedures in this area need to be improved. I've been asked to comment about H.R. 2128, the Due Process Restoration Act of 2017. H.R. 2128, I believe, is a step in the right direction, but it may in fact go a bit too far and cause the effect of causing the SEC to initiate all enforcement actions in federal district court. Yet not all enforcement actions require the formality of federal district court. Some cases, such as those involving disciplinary actions against registered investment personnel and so-called follow-on actions, could be adequately brought as administrative proceedings. I've also been asked to comment on H.R. 5137, entitled Securities Fraud Act of 2018. From my experience, I generally agree with the observation in that bill that imposing different state regulatory requirements for civil securities fraud on national markets increases risk, creates inefficiencies, raises cost, and can harm the efficient operation of these critical markets without providing material investor protection. While I think that H.R. 5137 represents a thoughtful and encouraging effort toward greater uniformity and predictability, I would offer 2 suggestions. First, consider adding a dollar threshold above which the cases could be preempted by the federal enforcement regime and below which would still be within the state realm for enforcement. States are oftentimes the front line on these smaller microcap fraud cases involving public companies. And the second consideration would be to, with that added threshold, to also add related cases, such as those against underwriters, officers, and directors. That would avoid the split federal-state enforcement of what really is the same case in controversy.
Gentleman's time has expired.
Thank you, Mr. Chairman.
Thank you. Mr. Borg, you're recognized for 5 minutes.
Thank you and good afternoon. I'm Joseph Borg, Director of the Alabama Securities Commission.
Can we just make sure that your microphone's on, that red light, red button right in front of you? There we go. Thanks.
And President of the North American Securities Administrators Association. I am privileged to have served as Director of the Alabama Securities Commission since 1994 and have been elected as NASA's President 3 times. State securities regulators have protected Main Street investors for the past 100 years, longer than any other securities regulator. We are responsible for administering state securities laws that serve to protect your constituents from fraud. We are often referred to as the cops on the beat because we are the regulators closest in proximity to your constituents. So thank you for the honor to testify before the subcommittee. The committee has requested NASA's views on 2 bills. H.R. 5037, the Securities Fraud Act, would amend the Exchange Act to prohibit states from pursuing many civil securities fraud cases. The bill is drafted in such a way that a defendant would argue, and a court could find, that states are preempted from pursuing civil fraud violations in connection with any transaction involving publicly traded securities. This will place all retail investors at risk because such securities are widely held by the investing public. State anti-fraud provisions serve as a powerful deterrent to improper conduct by companies of all sizes. States' ability to pursue enforcement activity against issuers of securities, including independently and when necessary and appropriate, is one of the reasons investors have confidence in America's capital markets. Further, under the bill, certain state criminal securities fraud prosecutions must, quote, comply in all respects, end quote, with federal legal requirements, without defining what this means. Defendants in a state criminal prosecution will argue the broadest possible reading of this language. Thus, for practical purposes, this requirement will be preemptive in that no state judge will agree to suspend all state criminal law and procedure. Here's the way it would work. I'm the prosecutor. Judge, you've got to use federal law here. Mr. Borg, this is a state court. I'm a state judge. We apply state law. I suggest you go find yourself a federal prosecutor. Federal courthouse is over in Birmingham, case dismissed. And no one will be left to protect Main Street investors. I imagine that the fraudsters, including the ones I've prosecuted, would be very pleased with such a result. Finally, 5037 will deprive defrauded investors of a choice of forum. It represents a direct threat to state pension funds and other investors who seek to opt out of shareholder class action litigation and instead advocate on their own, as it would require them in all cases to litigate exclusively in federal courts. In summary, for all the reasons I just enumerated, which I will have discussed further in my written testimony, 5037 is a misguided and dangerous bill, enacting policies that will make it more difficult and in some cases impossible for state regulators, the regulators closest to Main Street investors, to hold accountable the most powerful companies on Wall Street, and serves no valid interest. For all these reasons, NASA opposes 5037 and strongly encourages the committee to reject it. Turning now to H.R. 2128, the Due Process Restoration Act, this bill would benefit SEC enforcement actions, the respondents in SEC enforcement actions, by providing them with a broad right of removal to federal district courts, and raising the burden of proof in SEC administrative proceedings from preponderance of the evidence to clear and convincing evidence. This bill will have adverse consequences for the public interest. As detailed in my written testimony, NASA sees no good reason for Congress to enact 2128, and several reasons why these changes would disrupt our securities markets and the efficient functioning of the federal judiciary. My written testimony addresses other issues, including SEC enforcement resources, the expanding marketplace for private securities offerings, strong penalties as a deterrent to fraudulent conduct, and the need for legislation granting the SEC authority to bring federal court claims for disgorgement and restitution for the benefit of harmed investors. I'll be happy to discuss these issues further. I will close by reiterating my opposition to H.R. 5037. In more than 24 years as a securities regulator, I don't believe I've ever seen a legislative proposal that so alarms and offends me. Should Congress pass this bill, my office's efforts, as well as my colleagues in your states, to protect investors from serious violations of the securities laws will be eviscerated. Real investors in your districts, you can call them mom and pop investors, call them Mr. and Mrs. 401k, but real investors, real people will suffer as a result of this misguided and irresponsible legislation. Thank you, and I'll be pleased to answer any questions you may have.
And with that, Mr. Quadman, you are recognized for 5 minutes.
Thank you, Chairman Huizenga, Ranking Member Maloney, members of the subcommittee. Thank you for holding this hearing today. A prosperous, growing economy needs efficient capital markets in order to grow. And those markets actually need a strong securities regulator to make sure that it is fair and balanced. Fair and balanced regulation of the capital markets provides certainty and confidence to invest and raise capital for both investors and businesses. In other words, we need a strong cop on the beat. We have seen the treatment of securities cases evolve over the last generation. We have seen a rise in the use of administrative proceedings that have made administrative law judges the primary means of adjudication. In fact, we've also seen these cases morph from being civil proceedings to being quasi-criminal proceedings. Before 2016, there were serious due process issues regarding the use of administrative proceedings. There is no discovery, no right of deposition, no jury trial, a lack of evidentiary rules, and the use of hearsay. Because of these concerns, in 2015, the Chamber issued a report with 28 recommendations to strengthen SEC enforcement and address some of these due process issues. We believe that there should be a continued use of administrative proceedings in ministerial matters such as stop orders, as well as license revocations. And if administrative proceedings are going to be used in more complex cases, then there need to be due process reforms such as discovery, deposition rights that conform with the federal rules of civil procedure. We also believe that there should be a right of removal for jury trial under limited circumstances so that a defendant and not a government agency decide if a jury trial is appropriate for a defense. We believe that these reforms will make the SEC a stronger enforcement agency, as well as give defendants the right of appropriate due process in order to defend themselves. These recommendations led to the first SEC amendments to their rules of practice for the first time in 20 years, and while some of those reforms were a good step forward, they are very limited and pale in comparison to those procedures that are in the federal rules of civil procedure. Additionally, the constitutional issues regarding the use of administrative law judges was not addressed by the SEC at that time and may be addressed by the Supreme Court within the next several days. The Chamber strongly supports H.R. 2128, the Due Process Restoration Act. We believe that this right of removal under limited circumstances is an appropriate way for a defendant to remove a case, a complex case, to district court where more complex cases have historically been treated in Article III courts. This would also allow for defendants to decide if they want to have a jury trial. We also believe that a standard of proof of clear and convincing is necessary since many of these proceedings are actually quasi-criminal in nature. The Chamber also supports the Securities Fraud Act. Under our constitutional system, we have a bifurcated system of regulation. Those transactions that happen in interstate commerce are regulated by the federal government, and those transactions that happen on an intrastate basis are regulated by the states. Under the 1921 Martin Act, the New York State Attorney General, through the listing of public companies on the New York Stock Exchange and NASDAQ, has become, over the last 15 years, a de facto national securities regulator. What is additionally troubling is that under the Martin Act, the New York State Attorney General does not have to prove intent to defraud. What we've also seen is litigation through press releases with selective press leaks being put out in the press in order to drive settlements. These name and shame campaigns are one of the reasons why we have seen a lack of desire of businesses to want to go public. H.R. 5037 sets up common sense guardrails to preserve the distinction between national and state cases. H.R. 5037 would not impact the ability of any state to bring a criminal case, nor would it impact the ability of a state to pursue a case for a sale of securities that was not done through a national exchange. We believe that the passage of these bills will help provide for stronger enforcement and the certainty needed for healthy capital markets. And I'm happy to take any questions you may have.
Gentleman yields back. With that, Professor Vollmer, you are recognized for 5 minutes.
Mr. Chairman, Ranking Member Maloney, and members of the subcommittee, I appreciate having this opportunity to talk about some of the issues with SEC enforcement. My written statement addresses 4 separate topics. I'm going to use this opportunity for oral comments to address 2 of them. One is the question about disgorgement and the limitations period, and the second is the role of SEC administrative proceedings. As I noted in my written statement, my comments are solely my own views and are not on behalf of any other person. I start out with a paragraph to try to set a tone for my written statement, and the theme running through all of my comments is that SEC enforcement of the federal securities laws needs to be tough but fair. Fair treatment of defendants helps achieve the goals of the federal securities laws, but it's sometimes a value in short supply. So let me talk about the disgorgement question and the possibility of extending the statute of limitations. We're thinking more about that issue because of the Kokesh decision. My view is that the 5-year period in 2462 is already too long, and it should not be extended, absent compelling empirical data that the SEC is not capable of bringing a large number of important cases within the existing 5-year period. I don't think we have that data, and I'm dubious that it exists, but that is the kind of research that the Congress would need to extend the statute of limitations. And the reason I'm opposed to extending the statute is because 5 years is a very long time already. Limitations periods are extraordinarily important to society, and you never hear anyone talk about the values protected by limitations period, except the Supreme Court when it analyzes statutes of limitation. The second reason that I urge you not to lengthen the limitations period is that in my experience there's a strong correlation between limitations periods and the length of investigations. And I view one of the principal problems with SEC enforcement today is that the investigations are too long. There are serious social harms that occur from SEC investigations and from unduly long statutes of limitation, and my written statement describes what those social harms are. My written statement also refers to another problem that I think Congress needs to address, and that is the SEC staff's use of tolling agreements to circumvent the statute of the current limitations period. So if Congress is thinking about extending the statute, I would urge it to consider the following additional factors. First, as I said, obtain information about whether a problem really exists and the size of the problem. And if the problem is limited to a certain category of cases, let's address the category of cases as an exception. Second, I've heard various people try to connect disgorgement and an extended limitations period to investor damage or investor loss. A limitations period should not be connected to investor loss. Congress has never given the SEC the power to calculate a monetary penalty based on investor loss or damage. It would be a dramatic break with the model that we currently use in the United States of allowing private plaintiffs to recover loss and having the SEC obtain different forms of relief. I'll spend 10 seconds on the second topic, and that is the role of SEC administrative proceedings. The basic problem is that they are inherently unfair to defendants. If Congress agrees with that, it has a couple different paths it could follow. One would be a very broad removal right. I favor a very broad removal right, and that would be to let the SEC make the first choice of forum, but then give every defendant in an administrative proceeding an unqualified, unreviewable power to remove.
Gentleman's time has expired. With that, I will recognize myself for 5 minutes for questioning. I appreciate the testimony that we have before us today, and maybe Professor Vollmer will continue kind of where you left off. Last month, the SEC's Division of Enforcement co-directors testified in front of the subcommittee that the SEC has been unable to collect over $800 million in disgorgement since Kokesh, which is not an unmeaningful percentage considering that they had imposed $4 billion in penalties and disgorgement since 2016. So fairly significant amount of money, in percentage-wise as well as money. But since Kokesh, many have called for extended that statute of limitations, and I'm just curious if you can briefly give some of that context and whether if there just are not simply clear statutes of limitations and what we can do to do that. And Mr. Bondi, I'd like you to address that as well. Does extending the statutes of limitations for disgorgement run the risk of allowing more time for the SEC to just investigate and bring cases, as Professor Vollmer was sort of drawing the correlation between that length of time. And maybe, Mr. Bondi, we can start with you.
Thank you, Mr. Chairman. Well, I do think extending the statute of limitations is going to create a tremendous risk that the SEC will have investigations that linger on for multiple years. And these wandering investigations are really a threat to shareholders of public companies, because oftentimes they don't lead anywhere, and they don't even actually lead to an enforcement case, but they cost the company and in turn its shareholders tens of millions of dollars. In terms of the extending the statute of limitations, I agree wholeheartedly with Professor Vollmer that I think the SEC needs to actually demonstrate what cases it could not have brought within 5 years. 5 years is the longest statute of limitations or repose under federal securities laws. I would like to see them demonstrate which are the cases that they couldn't bring. And they have the ability to seek tolling agreements from companies or persons that are under investigation, and oftentimes they do. So it'd be really interesting to understand what are those cases that still linger and make up that amount.
But certainly there's got to be examples out there of fraud discovered beyond that 5 years, and then how do you go back and deal with that? And is this somehow inconsistent with the SEC's traditional mission?
Well, I'd like to see what frauds haven't been discovered after 5 years. I mean, I hear a lot about that, and I hear that there were frauds that were discovered many years back, but I do think that...
would you put the Madoff situation in that category?
Well, Madoff, they did discover within 5 years, brought it. And keep in mind, too, the SEC does have the ability...
My understanding of that was the fraud had been happening for far more than 5 years.
It was, but as I understand, they also brought an action and disgorged an amount that it actually was greater than the amount that was even at Madoff. But in any event, the SEC has the ability also to, in cases of extreme fraud like that, to seek penalties and to seek other types of remedies that could then be put into a fair fund under Sarbanes-Oxley and distributed to shareholders to make up for any amount that somehow lingered past the 5-year statute of limitations.
Okay. And I've got a minute and 15, and I think, Professor Vollmer, you've been fairly clear both in your written and in your oral statements. Mr. Quadman, how often do the state enforcement agencies bring state charges that are substantially the same as those brought against the same defendant by their federal counterparts?
There's a study from Professor Amanda Rose from Vanderbilt that shows that federal enforcement agencies bring cases 91% of the time as state enforcement agencies do. And in fact, that there's even a split between those state securities regulators that are elected that bring 4 times as many cases as those who are appointed.
Are there cases where states then have brought enforcement actions even after the companies have already settled with the SEC?
That happens an awful lot, that there's a lot of duplication that is going on, and one of the things we talked about in our 2015 report was actually to get at that duplication issue.
Okay, and so, Mr. Borg, I'll let you address that a little bit as well, both that situation and then how do we further elaborate on how these actually are investigations that are kind of new and different than what's happened at the SEC?
Mr. Chairman, with regard to those cases, the big cases that we work with, and I'll give you examples, Comtronics, HealthSouth, Morgan Keegan, Enron, WorldCom, these are cases that my office was involved in. In each one of those cases, yes, there was a state component, but those cases were worked with the SEC, sometimes with FINRA. On occasion, there might even be a CFTC case. So the question is not whether or not they were completely separate actions. Yes, we do work on a cooperative and collaborative basis.
So you don't feel they were duplicative?
No, sir, I don't. Think about some of the cases that we've had in the past, especially the bigger cases, the mutual fund timings. That was all done cooperatively and collaboratively.
My time has expired. With that, the ranking member
Thank
is
you.
recognized for 5 minutes.
Following up with Mr. Borg, I'd like to ask you about H.R. 5037. Do you believe you would be able to bring any criminal securities fraud cases if this bill were enacted?
The way it's set up, it says I've got to apply federal law in all respects. I don't know if that means federal law in all respects, including civil procedure, criminal procedure, and all the other items that go with prosecuting a case. I'm a prosecutor. I know what needs to be done. With regard to a judge, if I have a judge sitting in state court who has been trained for state law, trained for state procedures, he is not, I guarantee, is not going to listen to me when I say, Judge, suspend everything you've been elected to do here and apply federal law. The times we apply federal law is when we're looking for some other guidance or something to apply to state law, but not apply federal law. At that point, his argument to me is going to be very simple. You're in the wrong court. The federal court's over in Birmingham. Go find yourself a federal prosecutor. Now, I will have to find a federal prosecutor to take the case because they're the ones, DOJ, that prosecute those criminal cases in federal court, not state securities regulators.
And so under this bill, the Department of Justice would be the only agency with the authority to bring a criminal securities fraud case. Given that the Department of Justice has limited resources and only brings a small number of criminal securities fraud cases per year, do you believe that this bill would effectively allow some securities fraud to go completely unpunished?
Yes, ma'am, especially the smaller ones. Now, they may have an interest in some $10 million case, but as a practical matter, given the priorities of the U.S. Attorney's Office right now, which include the opioid addiction issues, immigration issues, and whatnot, there is insufficient staff there to worry about Mrs. Johnson in Elba, Alabama, who was taken on a $10,000 churning case in listed stock securities. That is not going to be a case they're going to try. In essence, I can't bring it. They won't bring it because they don't have the resources or the inclination. That means that harm goes unresolved, and that's just too bad for Mrs. Johnson. We can't have that.
Okay, thank you. Stepping away from the criminal fraud issue, I'm still extremely concerned about preempting even civil securities fraud laws. Mr. Borg, could you talk a little bit about what kinds of civil securities fraud cases this bill would prevent you from bringing? And can you talk about any specific examples of cases you've brought recently?
Yes, ma'am. Let's talk about listed company cases, and I'll just list them. I gave some earlier. One of the first cases I prosecuted against the New York Stock Exchange Company was Comptronics. It was actually located in Alabama for fraudulent invoices, and basically they raised their stock price with phony information. We were involved in the HealthSouth case. We worked with the U.S. Attorney's Office. Morgan Keegan was a subsidiary of one of the 15 largest banks in the country. Enron and WorldCom, we worked on behalf of the retirement systems and made a recovery there. The types of cases on the smaller scale will include churning listed securities. I gave you the example of maybe Mrs. Johnson in Elba, Alabama. On the broker-dealer side, engaged in pump and dump to manipulate sales of securities, that happens a lot. Also on the broker-dealer side, recommending unsuitable listed securities, usually tied with churning or just to make some commissions. On the advisor side, again, pushing an overconcentration of listed company shares. These are cases we see on a regular basis, and we strive to enable our residents to recover their savings when they fall victims to such frauds. With a preemption, that's not going to happen, and I don't know anybody else who will do it.
Okay, do you think that it's appropriate for the federal government to tell states how they can and can't define fraud?
I think that's for my legislature to decide. My legislature has decided what the elements are. Now, I will say this. 43, 44 states have the Uniform Securities Act, so we're fairly similar because we do, under the Uniform Act, same folks that brought you the Uniform Commercial Code, the Uniform Probate Code, the Uniform Gift to Minors Act, and whatnot. So my legislature defines what it says is required in my state, and my job is to enforce that, same with as occurs in every other state.
Thank you.
Yes.
And finally, what do you think, you said you thought this bill was particularly dangerous, and why do you think it would be particularly dangerous to enact this bill right now?
You've already heard testimony from others about the decrease in the SEC's case numbers with regard to bringing cases. We are the ones on the beat. We hear the first cases We're the ones that know all the complaints. We're the ones that actually will bring those cases. If they're coming down on numbers, that's more duty on us. We have a duty to protect our citizens, and we intend to do so.
Thank you very much. My time has expired.
Gentlelady's time has expired. With that, the Vice Chairman of the committee, Mr. Holmgren from Illinois, is recognized for 5 minutes.
Thank you, Mr. Chairman. Again, thank you all for being here. Section 881 of the Financial Choice Act would require the SEC to establish a process for closing investigations. Specifically, it calls for the Commission within a timely manner, two different things. One, to make a determination of whether or not to institute an administrative or judicial action in a matter or refer the matter to the DOJ for potential criminal prosecution. And number two, requires the Commission to inform the subject of the investigation that the matter is closed if the Commission does not pursue an action or defer it to DOJ for criminal prosecution. Mr. Quadman, wonder if I could address my first question to you. Can you discuss how this provision would prevent the Commission from abusing its investigation powers? Are there instances where investigations could remain open despite little or no reason to impose this burden and uncertainty on a market participant? And what are the effects on a public company when they're required to disclose an investigation, even when there is not necessarily a finding of guilt?
So the reason why we started looking at SEC enforcement in 2015 was that we had released a managerial reform SEC report in 2011, and one of the last recommendations in there was about this issue of cases being open and not being closed. So there are numbers that are kept at the SEC as to cases being open, but they were never closed. And as a result of that, we actually had one of our members come in and started to talk about how there was a small, there was an issue that they had with an internal control dealing with tax. It was referred to the SEC by an employee. The SEC came back. What it then did is it created this whole situation where that company had to preserve all of its emails at the cost of $1 million a month. That case went on for years, and there was never indication from the SEC as to what direction that case was going in. Additionally, it should be, we should also understand too, for that company, they actually corrected the problem as soon as they were told about it. But again, this dragged on for years and for a very long period of time.
Thanks. Professor Vollmer, your testimony notes that the SEC enforcement process should, among other things, allow for an ability to bring cases that lack merit to a rapid close. Would you support legislation requiring the Commission to establish a process for closing investigations, and are there any specific criteria that the Commission should consider when establishing such a process?
Thank you, sir. I would support that. I think the principal issue is a time limit, and that's what the legislation needs. That's a very awkward thing. That's why I connect the length of investigations to limitations periods, because that's how you see the SEC staff decide on how long cases can be investigated, is when do they have a deadline set by the statute of limitations. So I would be in favor of that. I referred specifically to early mechanisms for testing the merits, specifically during administrative proceedings, so during the litigation phase, and there is not currently the equivalent to a motion to dismiss.
Section 884 of the Financial Choice Act would require the SEC to institute a process to permit recipients of a Wells notice to appear before the Commission or its staff in person and to vote on whether to bring an administrative or judicial action against an individual. Again, Professor, can you please discuss how this would improve due process for enforcement of the securities laws by the Commission? And are there any cases in which the Commission's delegation of authority to the Director or direction of the Division of Enforcement is inappropriate?
There are inappropriate delegations, in particular the delegation to the director, which has now been subdelegated, about the ability to open what's called a formal order of investigation, essentially the power, creating the power to issue subpoenas. That is wholly inappropriate for the commissioners to have delegated to the staff. And so I would encourage you to look at that. Repeat the first part.
Yeah, the first one was, how would you improve due process for enforcement for the securities laws by the Commission?
I've addressed some of these topics in a law review article that I wrote, and so rather than go over those points, let me address the one particular point that you mentioned, and that is allowing an oral, allowing commissioners to attend an oral Wells submission. I actually don't think that would make a big difference in very many cases. Of course, it might in a few. But the lawyers always have the opportunity and take the opportunity to meet in person with the senior staff of the Division of Enforcement. You're correct, they do not get a chance to meet with commissioners. That might be useful in some circumstances, but generally I think it's more effective for the lawyers to submit their views in writing, which is what they do.
Thank you. My time's expired. I yield back.
Gentleman's time has expired. With that, the ranking member is recognized for 5 minutes for questioning.
Thank you very much. I'd like to direct this question on disgorgement to Mr. Berg. In your view, is the Supreme Court's decision in Kokish versus SEC that SEC disgorgement is a penalty subject to the 5-year federal statute of limitations consistent with earlier jurisprudence on disgorgement?
My opinion on the Kokesh case is that the SEC should do everything they can to get money back for investors. The statute of limitation issue, we actually faced that in Alabama not too long ago. The Supreme Court had issued a case that a decision that, of course, the cause of action for recovery and for criminal penalties and everything else started from the date of the inception of the crime, occurrence, whatever it was. We fixed that. We fixed that unanimously in my legislature by going to 5 years from date of discovery. So that's one alternative you might want to consider. So the question is, how long did it take to discover it? I think that issue was mentioned earlier by the chairman. In the current frauds, it takes a long time sometimes to find these frauds. The fraudsters are hiding the information, whether it's financial information buried in a financial statement of a company, or convincing the victims not to report. So the statute of limitations, if it starts from the date of the occurrence, in many cases is not going to allow for recovery. I do not believe a disgorgement or recovery to investors should be considered a penalty. And I do not think there should be a statute of limitations on recovering for the victims of a crime. The idea that the statute of limitations should be cut off at 5 years, no matter when it occurred or when anybody knew about it, only encourages those fraudsters to hide it as long as they can. And that is not in the public interest.
Thank you very much. Let me just move on to H.R. 2128, Due Process Restoration Act of 2018. Continuing with you, Mr. Borg. H.R. 2128 would help alleged fraudsters by allowing them to choose where their case is tried. What's more, this bill would further help these bad actors by subjecting the SEC to a heightened burden of proof or when an enforcement is brought in an administrative form. Could you describe how this bill could affect the SEC's ability to effectively enforce federal securities laws, and how do administrative proceedings help ensure efficient policing of our capital markets?
Yes, ma'am. This bill will benefit respondents in an SEC enforcement actions by providing them the broad right of removal to federal district courts. I've been a prosecutor a long time. Venue is usually selected in both federal and state courts in the best interest of the public, not the best interest of the defendant. If I was a defendant and I could move to federal court for significant delays, and I was financed enough, that defendant could continue to his business until that case is over. This will invariably lead the SEC, because of the change from preponderance of evidence to clear and convincing in the ALJ matters, to either go straight to federal court and therefore overload the federal courts. That's a possibility. The bill would raise that burden of standard to the point where we're going to have inconsistent decisions. The same fact pattern, the same type of interpretation of law. Well, if you're in ALJ and you're clear and convincing, well, that's one standard. And let's go to federal court and have a different standard. The precedence on that is going to be difficult to resolve. And I think now you've set two different standards for one particular law. The SEC might likely forego bringing enforcement actions through the administrative process. If that's the case, litigating those actions will require a lot more time, a lot more money and a lot more resources.
Thank you very much. I think we should all be concerned about any and all efforts to tie the hands of the SEC or to undermine their ability to do what it is they are mandated to do. So I think that we need further clarification on some of these issues that are not only in 2128, but in some of the other legislation that may be coming down the pike. And I thank you for being here, and I yield back the balance of my time.
Gentlelady yields back. With that, gentleman from Minnesota, Mr. Emmer, is recognized for 5 minutes.
I thank the chair, thank the panelists for being here today. I'd like to get into it this way. To have a valid and credible justice system, and maybe Professor Vollmer, I'll start with you, since you do this in the academic world, and you have to present this to folks. In my perspective, to have a valid and credible justice system, number one, you need a clearly defined rule of law. Two, you need a fair and impartial process to resolve alleged violations of laws, disputed claims. In short, that's the due process piece. People have to have the ability to have a fair and impartial arbiter or someone that decides it. And three, and I think this is incredibly important and often underestimated, you need the public's confidence in the legitimacy of the law and of the process that actually metes out justice. We've been asking, or I've listened to my colleagues ask a lot of questions about the state and federal systems today, and unlike some of the testimony I've heard today, I've got a lot of confidence in our state court judges, and granted, I only practice civil law. I wasn't over on the criminal side very often. But if you went into a state district court and you had a state district court judge and you had a case that was going to be the state law preempted by federal law, state judges are entirely capable of applying the federal law. It's not that far a stretch to imagine them being able to do it. But if you're on the other side of the bench, and you've got the state people you got to worry about, you got the federal courts you got to worry about, and then you got the SEC too that you have to worry about. I'd like to talk about these administrative proceedings at the SEC. Professor, do all of the federal rules of civil procedure and the federal rules of evidence apply to SEC administrative proceedings?
None of them do.
Do respondents in SEC administrative proceedings have the same discovery rights as defendants in federal court, district court proceedings?
No, they don't.
And just so anybody who hasn't practiced in a court of law understands, that's the ability of the defendant to find out whatever the other side has that they're accusing them of violating or doing wrong.
And more importantly, obtain information from third parties.
Right. Do respondents in SEC administrative proceedings have the right to a jury trial?
No, they don't.
And I know, Mr. Quadman, in your opening statement, you referred to some of this. Are there time limits in terms of when an SEC administrative proceeding needs to be completed, Professor?
Yes.
How does this compare to the time limits in a federal district court proceeding?
There are no time limits in federal district court proceedings.
So the argument that we're going to have different standards being applied if we pass some reform, well, we already have different standards being applied, correct?
There are many differences between administrative proceedings and federal district court proceedings.
Are you concerned, Professor, that respondents in SEC administrative proceedings have fewer due process rights compared to those who are actually having their case or their future determined in a federal district court proceeding?
Oh, I think that we should be deeply concerned about it.
My colleague, Warren Davidson from Ohio, has a bill, H.R. 2128, called the Due Process Restoration Act. Have you taken a look at this, Professor?
I have, yes.
And can you just comment on how this could, well, let's talk about facts first, because I talked about the perception, right? You have to perceive that you have a fair and impartial process. Isn't it true that over the past several years, the SEC has been picking its own forum, its administrative procedures, and that it's been winning more and more in its own forum?
I think the data is actually not entirely complete on those two questions. I think there are open issues about the data.
Well, let's, prior to the passage of Dodd-Frank, the SEC historically brought approximately 60% of its new cases as administrative proceedings. In contrast, over 80% of the new enforcement actions in the first half of FY 2015 were filed as administrative proceedings. So they are clearly filing more as administrative proceedings.
Yeah, I think you have to be careful about cases filed versus settled cases filed.
Well, but let's attack that quick as my time's running out. That's the problem. They've been bringing them in administrative proceedings that they have the advantage. They've been winning on above average numbers, and guess what? Now they just file them, or they threaten to file them, and you don't want to go through that process, so you pay before it ever happens.
Well, my point's slightly different. Defendants sometimes prefer to when they're going to settle at the initiation phase, they would prefer to settle in an administrative case rather than a federal district.
Well, I appreciate it. You and I have a difference. I think many of them settle because the cost that they are going to have to put up to fight the government just doesn't make it worth it, and that's why we should change this law.
Well, we don't have a difference at all. I agree with that completely. This is solely a question of what form.
Gentleman's time has expired.
Thank you. I appreciate it. We'll continue this offline.
The gentleman from California, Mr. Sherman, is recognized for 5 minutes.
As we go down this road, I should comment that both the costs and the benefits of securities enforcement are far greater than we might think at first blush. The costs of securities enforcement not only include the salaries of Mr. Borg and his compatriots and those of his brethren at the SEC, but they include the private sector cost of complying, but not just the private sector cost of complying when there's an investigation, but also all of the business opportunities that aren't pursued, because one more reason not to do it is this whole expensive process, the jobs not created. On the other hand, the benefits of securities enforcement are greater because we tend to focus on, here's Enron, here's Madoff, here's how much money was recovered for investors. That is just the tip of the iceberg on the benefits of enforcement. The chief benefit of enforcement are the frauds that don't happen, the disclosures to investors that are made more clear, the corners that are not cut. Mr. Borg, you pointed out a number of areas in which the statute you criticize, or the proposed statute you criticize, is unclear, and I would just say that we shouldn't, at this stage, be urging people to vote against legislation because it's unclear. We should be urging the authors to make it clear. And your earlier testimony identifies certain areas where the statute should either do the extreme thing that you don't think we should do, or clearly not do that extreme thing. But we shouldn't. We should clarify statutes and then decide. Mr. Quadman, we've got a unique history in this country that has led us to shared sovereignty between a federal and subnational governments. And so we have securities law enforcement at both the national and subnational level. Does any other country do it that way? It seems very peculiar to anyone not familiar with American history.
No, most other nations do it on a national level. Canada does do it a little differently, that they have their securities regulation done on the provincial level. But I do want to add that I had
But there's no country that does it at both levels.
No.
And there's no evidence that the German stock market or the British stock market is a place for fools who want to be defrauded because they benefit only from one level and not two levels of securities enforcement.
Correct, and in fact,
correct. I do want to go on. Mr. Bork, we tend to focus on the big companies that do register with the SEC, that do big things, that have big pots of money that we can go after, and at least try or pretend to comply with our securities laws. Got a offering from a initial coin offering. Anybody can invest. No government official has ever been asked to review this document. There's no investor protection at all, and they imitate, by calling it an initial coin offering, the documents that are filed when there is So why haven't you protected the people of Alabama from the DDF initial coin offering and similar complete failures to even acknowledge that securities laws exist, except for the purpose of imitating those investment documents created in compliance?
We have a number of cases ongoing. I can cite about 8.
But I mean, these folks, shouldn't this just be a slam dunk? I mean, they're offering an investment to the public unregistered by anywhere.
We do have a number of cases pending. Some respond to our cease and desist as we do the investigations. A lot of them are considered securities. Some are considered commodities. We have jurisdiction for both. NASA, 44 states, just completed a crypto sweep with 75 potential defendants.
But the DDF initial coin offering is still taking in money right now.
I'm not familiar with that particular one. I could cite a lot of others. I'd be more than happy to take a look at it and, if necessary, bring an appropriate action. I just don't know that particular one. But considering the 75 that we've looked at.
And will you be putting people in jail or just stopping them from defrauding people of additional funds?
That depends if they're overseas and we can get them or not, and that depends on whether or not there was an actual fraud where the money's been taken, received, and spent. In essence, if it's lying, cheating, and stealing, yes, we should. Can I get them? Do I have jurisdiction? That's something we'll have to look at on a case-by-case basis. But we are not ignoring this section.
Well, please propose any new legislation you need.
Yes, sir. We
The
did
gentleman's time has expired. The chair recognizes the gentleman from New Jersey for 5 minutes.
Thank you.
Well, thank you. Mr. Quadman, do you believe that duplicative state and federal regulation is chilling interest in our public markets?
There's no question about it. It's, as I said in my oral statement, it's one of the reasons why businesses aren't going public. And as I was going to mention before, I had a meeting with the Deputy Governor of the Bank of England a few years ago, where he was directly complaining about that and started to talk about how that is going to impact the ability of the U.S. to be competitive globally.
And does it negatively affect our global competitiveness?
It absolutely does, because it is. You can have a situation where New York State, through the Martin Act, is suddenly, let's say, with the financial analyst issue, is entering into a settlement that regulates things nationally that also international companies have to comply with.
Mr. Bondi, are you familiar with the Securities Fraud Act? Have you reviewed it?
I am.
Mr. Borg tried to make an argument that because the bill doesn't specify whether it's federal procedural or substantive law that we're talking about, that it would effectively shut down any state AG prosecution of criminal fraud. I don't concede that point, but if that were true, that is so easily remedied by amendment that could be clarified in a moment. So I think that's more of an excuse than a real reason. But let me ask you, since you're familiar with the bill, is this accurate, that all criminal fraud, whether it's public or not public companies, all criminal securities fraud would still be at the state level, that non-public companies would all be at the state level, that public companies that are not engaged in interstate commerce would all be at the state level? Is that true?
That's true.
So this is a very narrowly defined bill that is only targeting public companies who have to report immediately if they're even accused of civil fraud. This trial by press release, so they're merely accused of civil fraud. They have to report it to their shareholders with great negative effect on their companies, and it makes them less competitive on the world stage. Would you agree that this is a very narrowly defined bill that is simply protecting public companies engaged in interstate commerce?
Yes, Congressman, I think this is very narrow, and I would disagree with Mr. Borg about churning cases as an example of something that would be preempted. As I understand in my reading of the case, those types of cases could continue at the state level. And Congressman, I think that it could be even further narrowed and still achieve the goals by perhaps inserting a market capitalization amount.
Well, I want to explore that with you. That's actually what made me turn to you, is I heard that point, and I'm concerned as well that we don't take cops off the beat. I think that was Mr. Borg's expression. That's not what I'm after here. I am not trying to stop state AGs from going after bad actors. We have a responsibility to protect people. But there are a handful of states that do not use a uniform definition of fraud, and they are wreaking havoc on public companies. And since some of them, like New York, for example, there's a nexus between nearly every public company in the country and the New York AG, the lack of that state alone adopting a uniform standard gives that particular AG the ability to wreak havoc across public markets, which they've done successively, AG after AG. But I do want you to explore your suggestion. You mentioned in your opening remarks that you thought that some sort of a size limitation might help. Could you unpack that a little bit?
Yes, Congressman. In other areas, Congress has imposed certain capitalization amounts in terms of preemption. For example, in the registration of hedge funds, there's an amount above which the hedge fund has to be registered at a federal level. Otherwise, if it's below that amount, it doesn't have to register with the SEC. I would agree that in many cases, especially with micro-cap fraud cases, very small public companies that are traded on national exchanges, the states are oftentimes the front line of those cases. I agree with that statement by Mr. Borg. I think one way to address this in the legislation is to put in a market capitalization amount about the issuer. Maybe it's $50 million of market cap.
I'm running out of time. I'd actually like to explore that with you. One last question. Professor Vollmer, I've tried to strike a fair balance between protecting states' policing powers and preserving regulators' ability to pursue fraud within their borders and giving public markets a life here. Do you think that this bill strikes that balance?
I think it does excellent work in trying to strike a balance. I actually think it's too narrow. I think that there should be broader federal preemption, but I understand there are competing considerations.
The gentleman's time is expired. The chair now recognizes the gentleman from Georgia, Mr. Scott, for 5 minutes.
Thank you, Mr. Chairman. First of all, I want to preface my remarks by just sharing with the panel that there's some good points in this legislation. But I have a few troubling concerns here that alarm me since the Trump administration has taken over. First, if you recall, in February of 2017, then Acting Chairman Michael Pivovar revoked subpoena authority from roughly 20 senior enforcement officials, which meant only the director was left to approve any formal investigation. Then the second troubling point was that the Trump administration made a decision, as you recall, to stop all hiring, which resulted in the SEC imposing a strict hiring freeze, which has prevented the SEC from even replacing the departing staff. But it doesn't stop there. There have been actions in our courts with the Supreme Court ruling of Kokich versus the SEC that has resulted in significant crippling of the SEC's disgorgement authority, according to current co-directors of the Enforcement Division. And finally, we mustn't forget the Republicans' efforts here in Congress to never increase the SEC funding for the SEC Enforcement Division, which even though has zero effect on our national deficit because the SEC is funded by fees. So you can see, taken all together, sort of very troubling. Now, Mr. Quadman, I want you to know that I agree with you in the goal of the Chamber of Commerce. I've always been at the front of the spear here in this committee in making sure that, as you put it, I couldn't have put it any better. Quote, you said in your report that there needs to be identifying problems and shortfalls of our financial regulatory system so that the United States can compete in the global economy. And I add, remain and always remain number one in the global economy. But with this work going on in the administration, I kind of get skeptical about whether legislative action is necessary. So sort of let me ask the panel, do you think we have conclusive evidence here that H.R. 2128 and H.R. 5037 are solving serious problems in our markets? And especially you, Mr. Berg, do you think that these two bills are necessary?
No, sir, I do not. And I think that there is a misconception here about what is stopping IPOs or further development. Let's take a look at a moment for history. Back when I started 24 years ago, the private sector, the private market for capital was very, very small. It has grown. Congress has mandated it. It has passed laws to encourage the shift from IPOs to the private market. The private market now is bigger than the public market. That's one. The second thing, of course, is that the crowdfunding, Reg A, Reg A Plus, is another alternative vehicle for capital formation. So the capital formation shift has occurred at Congress's direction. I don't pass a positive or negative on that, but to say that the capital is decreased in the public sector through IPOs or whatnot is incorrect unless you take into consideration what we have done to move that sector from public to private. And I think that's an important factor that has not been considered. Just looking at the number of IPOs is not going to make it.
Right.
Mr.
Yes, Mr. Corbin.
Yeah, Mr. Scott, if I can answer. We think both bills are important. Number one, 2128, we don't have due process in the administrative proceedings at the SEC. And in fact, it's been reported where SEC staff has talked about the use of ALJs in administrative proceedings because it's the home field advantage. And, you know, this would correct a wrong where the government and not the defendant decides if they should have a jury trial. 5037 is also very important, too, because the Martin Act, we have to understand this. There's a confluence of public companies being listed on the exchanges in New York and this law where now the New York State Attorney General can be a national regulator and has sought to have that role. We should also remember that even yesterday, the New York State Court of Appeals issued a ruling where they issued concerns about the fact that the Martin Act does not provide for a proof to defraud or intent to defraud, which they have now limited the statute of limitations from 6 years from common law fraud to 3 years.
Right. I wanted to just put this into Mr. Davidson and the authors of the bill real quick. If they felt that if they could, within the bill, increase the funding at the SEC Enforcement Division, and would you guys be willing to urge the administration to lift the hiring freeze? If you could do that, then I'd like to look at it more carefully.
Gentleman's time has expired.
Is that possible?
They'll have a chance to maybe respond at their questioning. Next, we'll recognize a gentleman from Maine, Mr. Poliquin, for 5 minutes.
Thank you, Mr. Chairman, very much. Appreciate it. Thank you all for being here today. It's so important to make sure we do everything we can to help our businesses grow and expand and hire more workers and pay them more. And you can see what's happening with the GDP growth now, which is about double what it was, you know, a short year and a half or so ago. So things are going in the right direction. And I'm very interested in Mr. MacArthur, my terrific associate from New Jersey, his bill, H.R. 5037. And I'm sure you folks have been discussing it today. I've been in and out a little bit here, but you know, my concern here is a constitutional concern when it comes to, you know, the 10th Amendment and states' rights and everything else, but at the same time, making sure that we make it as easy as we can for businesses to sell themselves or part of themselves to the public. It gives an opportunity for small savers in the state of Maine to invest in America, and at the same time, allow these companies to raise the capital they need to be successful. Mr. Quadman, if you don't mind commenting on this, and then I'll turn it over to Mr. Borg, too. I'd like to hear what you both have to say. Do you think that the SEC would still be able to do its job, enforcement job, effectively if they were the sole entity dealing with companies listed on national exchanges?
Yeah, so first off, I think we have to remember the Founding Fathers made this decision with the Constitution 200 years ago that if there's a transaction in interstate commerce, the federal government's going to regulate that. If it's intrastate, then it's going to be the state that's going to regulate that. So I think that's a very important distinction that was made with the founding of the Constitution. I think it's also important to remember here, too, that 5037, number one, preserves a right, in our reading of it, preserves a right of states to pursue criminal actions. It preserves the rights to take other actions. However, when you're dealing with a statute such as the Martin Act, and as I said earlier, with that confluence of those exchanges being listed in New York, that it would have those cases go into federal court because we're dealing with an interstate commerce issue. That Vanderbilt study that I had mentioned earlier looked at 2,000 public companies and found that the SEC was bringing cases, or federal agencies were bringing cases, and 91% of the cases that states were. So we're not going to see a drop-off in enforcement, but we're going to see the proper rationalization as was mandated under the Constitution with this bill.
Thank you very much, Mr. Quadden. Mr. Borg, would you care to comment on this issue? We have a terrific state regulator in your space, Judith Shaw up in Maine. You might know Judith. She's wonderful. And
I do.
And she's weighed in on this, so I'm trying to sort this out and see.
Yes, sir. As you know, she has sent to you a letter outlining her objections to 5031. With all due respect to Mr. Quadman, there's one item of the Constitution he forgot about. The states have a right to protect their citizens from fraud and whatever it might be. Also, with regard to the fact that states are somehow impeding this process, this committee has had over 20 hearings in the last number of years talking about increasing IPOs or what is impeding the ability to go public. And not one of those hearings has ever brought up state involvement as an issue. Private rights of, we've talked about Reg Ds and everything else. This Congress alone, 6 hearings have been held, and not one has ever said that the states are the problem. And so I think we're focusing on the wrong issue here. And the fact of the matter is that if states are going to protect their citizens from actions that affect their citizens, then they have a right to do so without being overridden by a federal preemption such as 5037.
Mr. Borg, before I run out of time, if you don't mind, I'd like to turn it back over to Mr. Quadman, because I know your body language was such that you might disagree a little bit with Mr. Borg. If you want,
Yeah, I just have to disagree with that last statement, because I have testified at a couple of those IPO hearings here at this committee. We have raised these issues before, and we have raised the Martin Act before. So this is not a new issue that's being raised.
Mr. Borg, you have the last word.
The Martin Act is a New York law. I think that that's something that the folks in New York should decide. I think that this argument over the Martin Act, if that's what we're talking about, the Martin Act, ought to be in Albany. I'm addressing 5037 that's going to affect my state and 49 other states. I am not here talking, I'm no expert on the Martin Act. And if this is a Martin Act issue, then I think it ought to be handled up in Albany or wherever their legislature meets.
To be continued. Thank you, gentlemen. Really appreciate it very much. Thank you, Mr. Chairman. You're back my time.
Gentleman yields back, and with that, we welcome our colleague and guest to the subcommittee, Mr. Capuano from Massachusetts, who is recognized.
Thank you, Mr. Chairman. I thank you for your indulgence. I appreciate it. I came over today because this is an important issue. Mr. Borg, could you tell me again what your title is?
I am Director of the Alabama Securities Commission. I'm the current president of the North American Securities Administrators Association.
What state was that again?
Alabama.
Alabama. Has Alabama changed? Are you now the bastion of liberalism like Massachusetts?
We're there to protect our citizens from whatever it takes.
I'm not aware. I mean, it's a lovely state, but I'm not aware that you have a reputation for being a progressive or a liberal. Not you, but the state. So that what you do is, in your estimate, within a conservative viewpoint, the protection of consumers.
My legislature has passed the laws. They have seen fit to say that we need to enter this space and protect our citizens, and we have done so.
And how many other states do this?
I hope all the other states do this.
That's what I thought. I'm under the impression that every state does this. Now, when we talk here regularly about insurance regulation. And on insurance regulation, I think I hear the mantra pretty much all the time to leave it to the states. Have you heard that argument relative to regulation of insurance companies?
I have. I understand that there is exclusive jurisdiction to the states with regard to insurance regulation.
Right, because they do
no
a decent,
federal-
they do a decent job, the system works.
And there's no federal regulator for insurance.
Right. I came today because all the nice talk is one thing, but, you know, the concept of taking protections away from small investors just strikes me as anathema. It just strikes me as, look, I mean, if the SEC's doing a great job, the truth is we don't need the states. But then you have to look me in the eye and tell me the SEC's done a great job all the time, and they haven't missed anything, and that the states are nothing but, you know, doubling up. And if that's the case, I haven't heard that from anybody, and I don't quite know why we're here. I'm not sure what the problem is we're trying to solve, and I'd really like to hear it. Look, every regulation is over-regulation to some people. I get that. But in this particular case, especially we have a gentleman from Alabama, no one has ever said that Alabama is guilty of over-regulating anything. And if all the states are over-regulating, I'd like to hear that from somebody in the panel. Are all the states over-regulating? Or is it just a couple of states you're trying to target?
Well, Mr. Capuano, I would just say, as I mentioned earlier, I think what we have here is a situation where we have one state where you have a confluence of the two major exchanges in the United States being located in that state. We have the Martin Act being used over the last 15 years in such a way that there's litigation through press release. There's never been a case brought into court except for once where New York State.
So we're here
law.
targeting one state.
Well, I think that's where we have the biggest problem, because that's where we have the New York State Attorney General has set themselves up to be a de facto national
Fair enough.
regulator.
I
That's
get
in tension with the SEC.
Then why don't we have a bill just to stop New York State from doing this and leave the other 49 to do it? Leave Alabama alone.
Our view is, and I have great respect for Mr. Borg and what he does down in Alabama. Our view of it is that our reading of 5037 is that it would actually just do that. It would take care of those cases up in New York. And if there's more clarity that's needed there, that's fine.
So all of a
We're
sudden,
happy to
if
look at that.
Massachusetts would have stepped, now one of the reasons the other states don't do it is because we know New York happens to be the biggest one of the bunch, and they kind of take care of business for us to a certain extent. At the same time, I'm sure you know that oftentimes when they move, many other states will join in with them. They are the lead dog because they're the biggest dog. So if, let's assume for the sake of discussion, that the entire state of New York were to go to sleep tomorrow and stop doing whatever it is you don't like about it, what if Mr. Borg stepped up and said, now that New York's not doing this, maybe we need to step up a little bit? What would that argument be?
I also remember the Massachusetts state regulators saying that people shouldn't buy Apple stock because it was risky. So I think it's really important to remember we have an SEC that is looking at these things from a national level, from an international level, and that we are talking about the sales of securities listed on national exchanges. If it's something that's not listed on a national exchange, that it falls within the purview of the states, we don't have a problem with that.
So the SEC has never issued a single ruling that you disagreed with. That's it. Good. I guess there's nothing wrong with that. That's a good thing if you feel that comfortable with them, because there's a couple of things they've done that I haven't agreed with.
We haven't agreed with some things either, which is why we also support 2128, which I would hope you do too in terms of due process.
I'm all for due process. What I'm
Gentleman's
not
time has
for
expired.
is taking people's protections away. Thank you,
Gentleman's
Mr. Chairman, for
time
your
has
indulgence.
With that, gentleman from Ohio, Mr. Davidson, is recognized for 5 minutes.
Thank you, Chairman, and to our guests, thank you for your expertise and for the preparation you've given, the testimony you've already given, and for the lengthy dialogue that's already occurred. As one of the sponsors of one of the bills that's been talked about a bit, it's nice to be able to discuss it, and a co-sponsor of Mr. MacArthur's bill. So I appreciate the committee for having this hearing and for devoting the time that it's taken. Mr. Quadman, in your testimony, you state that the administrative proceedings have, quote, created an imbalance within the system that endangers the rights of defendants and undermines the use of appropriate enforcement tools while raising important questions regarding the separation of powers between executive and judicial branches of government. This is one of the reasons why I introduced H.R. 2128, the Due Process Restoration Act, This bill provides respondents in SEC enforcement cases with the ability to have their case removed from the SEC's administrative proceedings and sent to a federal district court. Essentially puts them at parity with the SEC. If the SEC can choose their venue, so can the defendant. Could you please elaborate more about the concerns regarding separation of powers, and specifically how would legislation like H.R. 2128 help alleviate this imbalance?
Yeah, so as I mentioned earlier, if you take a look at the federal rules of civil procedure, none of the traditional things that you would see in an Article III court exist in an administrative proceeding at the SEC. I think one example I think is very illustrative of that, and that is of Nelson Obis at Weinfeld Capital. So he was involved in a case that went on for, I believe, 12 to 14 years, cost him millions of dollars, and he was one of the last people to get into federal district court before some of the changes with Dodd-Frank, which really shifted things into administrative proceedings. As a result of the right of discovery, he was able to uncover information that led to cross-examination, that led to his exoneration. And he has even said, had that case happened several years later, had it gone into administrative proceeding, he would have never had the right of discovery, he would have never gotten that information, he would have never had the cross-examination, he would never have been exonerated. So I think we have to be very careful. Let's forget for a second about if this is a securities issue or not. If we're going to have American citizens being brought before American tribunals where they don't have the right to defend themselves, I think what your bill does is it allows that defendant under certain circumstances and limited circumstances to go into federal district court and to get a jury trial, which in our view is a matter of fundamental fairness and due process.
Frankly, it's a constitutional protection. I think it's core to the oath that we all swore. You know, I think it should be a bipartisan thing to support and defend the Constitution in this way. I respect the arguments that, as a huge supporter of 9th and 10th Amendments, I respect some of the arguments that have been laid out here. But even as we talk about Mr. MacArthur's bill, the idea that there could be no limited safe harbor as a condition of going public, as a consequence of a publicly traded stock on civil litigation, I think misses the point. And I respect the emphasis on the Martin Act, but if you look at the things that were done in the name of investor protection, it was really advancing a cause on climate change, not investor protection, that not just New York, but Massachusetts, the Virgin Islands, Illinois, California, and others put pressure that affects investors, affects shareholders. So you have this market-distorting behavior that hurts all shareholders, including shareholders in my state of Ohio. And so you have a need for legislative certainty here. I am particularly interested in initial coin offerings. I'm working on a bill for that. And these offerings can present another avenue for businesses to raise capital and increase liquidity. We've seen a myriad of state and federal regulations, and now we're seeing enforcement action and perhaps regulation by enforcement is one of the concerns that folks have expressed to our office. And kind of a hope that somehow the courts create some sort of cohesive framework. Do you think these concerns about the patchwork hold water, or do you see a role for Congress bringing clarity in this matter for the SEC and CFTC to create regulatory certainty, Mr. Quadman?
We think there's definitely a role for Congress here. We, in fact, we are putting together our FinTech agenda, which we're going to look at ICOs, and we're going to release that next month, and Treasury is going to do something like that as well this month. We think there needs to be a strong regulatory structure around this, that there's investor protections, there's balance, there's fairness, and it's also important to remember this is also a matter of international competitiveness as well.
Very well said. I see my time has expired, and I yield.
Gentleman's time has expired. With that, gentleman from Arkansas, Mr. Hill, is recognized for 5 minutes.
Thank the chairman. Thanks for holding this hearing, and appreciate our panel and your expertise for coming down and spending the afternoon with us. We're grateful for your expertise on this topic. I have to say, from listening to the excellent dialogue, Mr. Borg and Mr. Quadman, thanks for bringing that kind of robust debate about these issues to the committee. Appreciate all my colleagues' involvement in it, because it really is helpful. We don't always get to do that in these hearings. To be able to drill down and have some exchange is helpful. And I hear the concerns that Mr. MacArthur's legislation is perhaps too broad for the North American security administrators across the country, and they have concerns about that and also their state's rights. So that's something that, maybe needs more work in the bill, because the issue of interstate commerce and international exchange competitiveness for listing is a big concern to this committee too. So it's a classic case of public policy where we're working to balance those interests. So, Mr. Borg, is there you have a couple of narrowing suggestions maybe on further tailoring that would get at this issue of international competitiveness, since our exchange and our listing entities are all in the state of New York? We're not moving them. I'm not going to foot the bill for that project, although New York tax structures may drive them out one day. But let's assume they stay in New York for now. Do you have some suggestions? Because I know you all probably had to talk about this in preparation for the testimony.
Well, certainly, I'm looking at this bill as how it affects my state and other states as well. I'm not versed in the Martin Act, and there's been a lot of discussion today about where the Martin Act is and how it applies and how it doesn't. I do know New York has filed with the committee a rather extensive letter on New York law, and I would be, out of my territory to talk about New York law. With regard to the idea that foreign markets may somehow are scared of this area, I will tell you that there are studies about, and I've heard this, overseas as well, that the markets in the United States, because of the protections afforded, the amount of regulation, is one reason why they are attractive to good overseas.
Well, I agree. We have the rule of law. We have terrific liquidity and terrific players, diversity of players, a lot of expertise in bringing companies to the public market and sustaining their marketability. We're the biggest in the world. We also have the largest section of buyers of that market. For now, we have many competitors around the world. But there is also data about the barriers of, if you are comparing markets and litigation is a concern to you. I saw some recent data, I think in April or March, from the Business Roundtable in their corporate governance survey that indicated that there are some foreign markets that are more attractive for certain kinds of listers. So I think this is an issue. I think Mr. MacArthur raises a good one, and we ought to be sensitive to it and try to find the right spot where we're not impeding the administrative responsibilities in the private placement market and broker oversight and firm oversight that you have in our states. Mr. Quadman, we've been working on our Jobs 3.0 here in the Congress on things that can enhance capital formation, and one that I noted in my last couple of decades of working in the securities industry is how Sarbanes-Oxley raised costs and didn't get any concomitant increase in efficiency or compliance by requiring a peekaboo-approved audit firm for small, non-custodial introducing brokers. And I wondered, would you support our idea of making that, it's gotten waivers in the past umpty years from Sarbanes-Oxley in 2002, but making a permanent waiver, would you support that?
Yeah, look, the Chamber's strong supporter of internal controls, but we support a waiver and we support the direction that you're going in. I think that one thing to remember, the first two letters in PCAOB stand for public company. And most of the brokers that you're talking about, number one, aren't public companies. Number two, don't hold securities. So that the audit that they are being subjected to by the PCAOB doesn't match their model. The other thing I would just say, too, is when you're taking a look at a Bernie Madoff situation, what you need is the bank records and what you need is the revenue statements, and you put those two things together, and you're going to find out if there's a problem. You're going to have that information, and what we're trying to solve here is not going to prevent that information from being in the hands of regulators.
Right. Thank you. Mr. Chairman, I'll yield back.
Gentleman's time has expired. With that, the gentleman from Indiana, Mr. Hollingsworth, is recognized for 5 minutes.
Well, good afternoon. I really appreciate everybody being here, and second what Representative Hill said about the vigorous debate that we have undertaken today. I think it's necessary and something that Hoosiers have been concerned about for some time and continue to express that to me every time I'm back home in district is some of the silent encroachment upon their rights of due process and ensuring that they have the opportunity to understand that which is being brought against them, and they have the opportunity to defend themselves vigorously in a court of law. And Mr. Bondi, I had a couple questions for you based on some of the testimony that you've had, so we may bond here for a moment, if you might. So I know that one of the things that you talked about before was some of the forum shopping, and that's particularly concerns me with regard to, I think it was the Cyan decision earlier this year by the Supreme Court, in that 33 Act class actions could be brought in state court and are not removable to federal court. I guess we had some concerns when that decision came down that ultimately this would lead to a lot of forum shopping. This would lead to also law being developed in different ways in different places versus a coherent system of law being developed all the way across the country from sea to shining sea. I wonder if you might be able to elaborate on that.
Yeah, I agree, Congressman. I think that's a real concern.
Yeah.
And, you know, what we're seeing, I think, in the defense bar is plaintiffs that are looking for the most favorable forum to extract the largest possible settlement.
Right.
And it exists also at the regulatory level, I think,
Right.
where what we're seeing here with the administrative law proceedings.
Yeah. Well, I know one of the things that Hoosiers are focused on, and really the previous governor of Indiana, Mitch Daniels, really talked about this a lot, is we all want to make sure that the bad actors that exist out there get hit with a sledgehammer. But ultimately, we don't want to impede capital markets. We don't want to inhibit good actors from being able to service their customers, to be able to create new innovations, and also be able to continue U.S. competitiveness around the world. And I think that's really important, that we don't develop law in a way that will continue to be a drag on overall capital markets effectiveness, but instead we create law that will ensure that bad actors are taken out of the market, but ultimately we're not harming good actors in the market. And another question that I had for you was kind of elaborating on the standard that the SEC demonstrate a reasonable approximation, quotation marks around that, for its disgorgement calculation. Just kind of better understanding how the SEC might develop that. Is there public guidance about that? What does that look like? But it certainly seems like a really wide spectrum.
Yes, Congressman, it definitely is a wide spectrum. And the difficulty is most of the cases the SEC brings are settled cases.
Mm-hmm.
So the standard that the SEC applies, this reasonable approximation standard, never really gets challenged in an Article III court.
Right.
And if it's an administrative proceeding, sometimes it never even reaches an Article III court,
Right.
and it's dealt with an ALJ judge. It's particularly poignant in the case of books and records and internal controls violations,
Mm-hmm.
where the SEC might take a books and records violation and then disgorge an extraordinarily high amount that was associated, for instance, with a foreign bribe,
Yes.
where instead of bringing an FCPA case
Mm-hmm.
for that foreign bribe, they bring a books and records internal controls case
Right.
and say all of the ill-gotten gains from that foreign bribe
Right.
were related to that one entry
Right.
that was incorrect in the books. So
Right.
there needs to be some standard here. I think either Congress should impose it or the SEC should come up with a standard by way it calculates disgorgement.
So again, I mean, we've talked a lot about forum shopping in the course of this testimony, but really talking about limiting the ability for these actions to be brought and really shop the different ways that they may be able to attack these actions to be able to get the largest penalty. And I think that that's what we're trying to hold back. We want to make sure that any nefarious activities by individuals, that they pay the price for that, but we don't want to shop around so that they pay the largest possible price in terms of the avenue taken. Is that fair?
That's fair.
Okay, great. And I think the other thing that this is something that you cited in your written testimony is the NYU study that the first half of 2018, the percentage of new enforcement actions against public companies, I want to make sure I get this right, were brought as administrative proceedings declined to 80%, down from 94% in the second half of 2017. Is this an encouraging trend that you see in response to some of the public outcry about this, some of the articles that have been about this, some of the challenges that have been brought to this process, or kind of what do you attribute that decline to?
Absolutely. I think it's the new commission, particularly Chairman Clayton and
Yes.
the enforcement directors, are very much cognizant about this perception of unfairness associated with the ALJ proceedings. I think they're taking better courses to determine when and where to bring ALJ proceedings.
Yeah.
I think these statistics are very, very encouraging.
Great. Well, look, I know a lot of times on this committee, we talk about esoteric financial products. We're talking about aspects of law that maybe don't touch everyday lives for Hoosiers, but what does touch them every single day is making sure that they have a due process and making sure they have confidence in the legal system and being able to defend themselves, or an individual accused of a crime is being defended themselves. So thank you all for being here and appreciate the testimony.
Gentleman's time has expired. And I would like to thank our witnesses today for their testimony. I think this was helpful. Without objection, all members will have 5 legislative days within which to submit additional written questions for the witnesses to the chair, at which point we will forward those to the witnesses for your response. We just request as timely a response as possible. And then without objection, all members will also have 5 legislative days within which to submit extraneous materials to the chair for inclusion in the record. So again, we appreciate your time, your expertise, and we look forward to continuing these conversations. So the hearing is adjourned.